Hi, we are on chapter 15 already, which is so crazy. Thank you so much for sticking along and watching all of these videos, and welcome to my channel. This chapter is all about landlords and tenants, and up next is property management with chapter 16, so it all kind of relates here. Remember to hit that subscribe button down below so you don't miss out on the next few chapters, and give this video a thumbs up if you're getting some good use out of it. Let's go. A lease is when the lessor, the homeowner, gives the rights and possession, the right of use and possession to the lessee, the tenant. In North Carolina, we have 3 laws that relate to landlords and tenant relationships, and they apply to all rents, to all who rent. There is the North Carolina Residential Property Agreements Act, the North Carolina Security Deposit Act, and then the Vacation Rental Act. They are all actually named based off of what they enforce, which is wonderful. Residential properties, security deposits, and vacation rentals. A landlord can be an owner, a property management company, or pretty much anybody with power. This person must keep up with repairs, keep the place safe, and comply with building requirements and codes. The landlord can be liable if they leave a home that is unlivable for a tenant. Smoke alarms are a type of safety requirement that are required. They must meet the local codes, and as a landlord, you must install 10-year lithium-ion batteries into your smoke alarm if they are not hardwired. This also applies to carbon monoxide detectors if there is gas in the house or an attached garage. As for bills, they can either be paid for by the landlord or by the tenant, whatever is negotiated beforehand. However, a landlord may never disconnect service for non-payment, right? A tenant has to be able to live, has to be able to survive. As for entering a property, a landlord may never go in unannounced.
Little pigs, let me come in. Here's Johnny.
Unless there is an emergency or unless it has been agreed upon by the person living there. If repairs or inspections are needed, a landlord can go in there to make those repairs and inspections if they are reasonable and if they give enough notice. In cases of domestic dispute, the tenant may ask the landlord to replace the locks on the doors, and the landlord has to do it, but at the cost of the tenant. If a victim gets a court order, they may cancel their lease with you with a 30-day notice. Now, as a tenant, you have responsibilities too, right? You must keep the place clean, you must throw away trash, you must maintain those smoke alarms that we discussed, and you are also responsible for any damages that aren't caused by normal wear and tear. Things like a leaky roof, leaking water through the ceiling, that's not really on the tenant because they're not the ones who are going up there inspecting the roofs and making sure that the roof is up to date. But like a hole in the wall, that's obviously on the tenant. For tenants that are in the military, they may also terminate their lease with a 30-day notice if there's certain conditions that are met, like they're going to be deployed for 90 days or more. Now, there are 2 main types of evictions. First one being constructive, which is where the landlord breaches for not maintaining the property or providing health and safety necessities. Then an actual eviction, which is where a tenant breaches the lease, and that's typically done with a non-payment. They just stop paying you. If there's an eviction, the landlord must hold all of the property for at least 7 days if all of that property together is worth more than $500. If it's worth less than $500, the landlord only needs to hold that personal property for 5 days. The process is actually very simple. You have a right to a hearing in 1 week, and the sheriff will deliver that notice to the tenant, and then a decision will be made that day. When it comes to late payment fees, there are max amounts that you can charge your tenant as a landlord. 5% of the rent or $15, whichever is greater. So typically the 5%. Remember before that I said there were 3 main laws when it comes to rent? Well, all the previous stuff was for the Residential Property Act. Now let's brush through the Tenant Security Deposit Act. All deposits must go to a trust account, and the amount you can get is broken down like this. So if it's a weekly rent that you're doing, you can only get a 2-week deposit. If it's month to month, you can only get a 1.5 weeks deposit. And if it's yearly or longer, really anything more than 1 month, then it is 2 months deposit. Now the deposit that you've gotten from your tenant that is now in your trust account can't be going out and blown on whatever you want, right? You can only use it for a few things. The following: non-payment of bills. So when that tenant stops paying those bills, you can start using that deposit. Intentional or negligent damage, holes in the walls. Missed payments, or re-renting costs if they move out early, and then the cost of removal of or storage for any of their personal property. Remember, 7 days if all that personal property is worth more than $500. And really any other eviction costs, going to court, things like that. Now, cleaning fees may not be taken out from the security deposit. You can charge for cleaning fees up front, like in the lease agreement, you can ask for that. The deposit that you get also must be deposited within that trust account within 3 business days. And then it must be returned when that tenant moves out within 30 days. 30 regular days. If the new tenant's address is unknown, you must hold that money to the side in your trust account for 6 months. After that point, you still don't get to keep it as a landlord, it goes to the government. Now, you may charge an additional pet deposit, but just remember, again, some insurances don't cover certain breeds of dogs, and I've learned this the hard way in one of my investment properties. When it comes to service animals, you can't discriminate against them or not allow them or charge for them. This is kind of like discriminating against the person who has them because the person needs that assistance. When a property that is being rented is then sold off to a new buyer, that lease is still valid. The new owner must continue letting the renter lease that property out for the full term of the agreement. The new owner now gets the security deposit and then manages that. And then we head to the Vacation Rental Act. Remember that? That's the third law when it comes to rent. A vacation rental is defined as where someone rents out a place for a vacation or recreation and lasts less than 90 days. And this is limited still to just residential type of properties, so not hotels or motels. When a vacation rental is sold, that is a material fact. All reservations need to be disclosed to the new buyer, and any reservation that is made in the next 180 days after closing must be honored. Now I'm gonna ask if you remember something from way back. Dream oils? Remember that? The L is for leases longer than 3 years, remember? So it must be in writing and it must be recorded. A typical property is freehold, right? So a rental must be a leasehold. And these are the concepts you should know about them. So they are estate for years, periodic tenancy, estate at will, and estate at sufferance. Estate years means that there's a definite start date and a definite end date. There is automatic termination here, and so no notice is required when the tenant moves out. You sign that lease for an end date, so it's expected that they'd move out unless they renew with you. Periodic tenancy is where you rent out a place month to month, day to day, week to week, whatever, and will require notice for that person to move out of that property. If they don't give you notice, then it just keeps renewing month to month, day to day, week to week, and so on. A year to year will require a 1 month notice. A month to month requires a 7-day notice, and a week to week requires a 2-day notice. Tenancy at will is typically a short-term period and usually pertains to like having a guest. Termination can really happen at any time. Think about a store having a local hot dog vendor out front, right? All right, it's time to go, you're hurting business right now. We tried it, it's not working. See you later. Estate at sufferance is when a tenant can legally stay and hold possession of a property even after that contract date ends. When it comes to renting, there are several different options a lessor or lessee may choose to go through with. There is fixed rent, which is the standard, like the flat rate, $1,000 a month for this rental. Then there is net lease, which is standard for commercial, and the tenant usually pays the bills and some of the repairs on that property. Then the percentage can be in place like at shopping malls, like the owner gets a percentage of the gross income of the store. Then the oil and mineral lease allows for companies to lease land for collecting resources, and full service leases, which are typically for office space and have some of the shared common areas. Similar to a sales contract, a lease agreement must be a mutual agreement, have consideration, legal capacity, and a legal objective, right? You can't rent out a crack lab to some scientist. Subleases are when your tenant releases to another person. You, the landlord, can prohibit this, of course. If the sublease is in place, the original tenant can still be held liable for some damages or any wrongdoings going on during that time too. You may have heard of the lease to own or option to purchase before. A lease purchase is a signed purchase where the tenant will buy that property when that lease term ends, while a lease option is where the tenant can buy when their lease ends if they chose to, but doesn't have to. Remember, that's the unilateral contract. So the termination of a lease agreement is very similar to the termination of an agency agreement, right? The lease will terminate when the duties are complete, when the term ends, when there's mutual cancellation, you both agree to cancel, condemnation of the property, the government takes that property, the tenant fails to pay, owner fails to maintain, and death does not actually terminate the lease. And this doesn't matter if it's the death of the landlord or the tenant. that lease is still intact. So if it's a landlord that dies, that renter can obviously still stay there. They're not going to get kicked out of that house. And if the renter dies, then their heirs are still responsible for covering the rest of that term. And last note here is that if a tenant does die, you have 90 days as a landlord to hold all personal belongings, just in case somebody tries to come and collect it. And you did it. You made it to the review, so let's hurry up and get through it. The tenant gets the right of use and possession from the lessor. There are 3 laws that apply to rentals in North Carolina, which the North Carolina Residential Property Agreements Act, the North Carolina Security Deposit Act, and the North Carolina Vacation Rental Act. The Residential Property Agreement Act applies to residential properties, not hotels. A landlord can be the owner, a property management company, a rental agent, or really anybody with power. They must comply with building codes, make repairs, and keep the home safe. Smoke alarms must come with a 10-year battery, and tenants replace those batteries from there. A landlord can't access a property unless there is an emergency. Reasonable access is given for needed repairs and inspections. Victims of domestic violence can have the locks changed on the doors. A tenant must keep the unit clean, throw trash, and make any repairs that are not from normal wear and tear. Military personnel can terminate a lease with a 30-day notice if they are being deployed or with a few other conditions. When landlords breach a contract, it's a constructive eviction. When a tenant breaches a contract, it's an actual eviction. The maximum late payment penalty is either 5% or $15, whichever one is greater. Security deposits must go into a trust account within 3 business days of receipt, and they must be given back to the tenant after the lease within 30 days. The maximum amount of security deposits you can collect is 2 weeks for a weekly lease, 1.5 months for a monthly lease, and 2 months for any lease greater than 1 month. You can't charge for or prohibit service animals. Vacation homes are material fact, and any bookings within 180 days of closing must be honored. The types of leasehold estates are estate for years, periodic tenancy, estate at will, and estate at sufferance. Fixed rent lease, net lease for commercial, percentage lease, MOG lease, mineral oil gas lease, and full service leases are your most important and common types of leases. Options to purchase are when your tenant has the option to purchase if they want to. Lease purchase is when the tenant must purchase that property at the end of their lease. If either party dies, the lease obligations are still valid. And that's about it. We're just knocking them out now one after another. A free way for you to show your support for this channel is by clicking the subscribe button down below. It's so easy to do, and please consider giving this video a thumbs up. The YouTube algorithm absolutely loves it, as so do I do. And so do I do. And so do I. Thank you so much for watching Chapter 15 of the North Carolina Real Estate Exam Prep. Up next is Chapter 16, which is all about property management, which again kind of relates to this chapter, so it should be fairly easy. See ya!